Welcome back to Law News Network. I'm Heather Hansen, and today we have a whole host of things to discuss with you. We are going to start in just a minute with my guest discussing the indictments that have come down and continue to come down this morning from Robert Mueller's investigation into Russia and their impact on the election, and also into Paul Manafort and his financial dealings. We'll talk about the indictments that have come down thus far today with my first guest. At noon today, we're going to be discussing Bill O'Reilly's defamation case that he has kind of brought against the gentleman who said something about him on Facebook. O'Reilly had threatened to sue that gentleman for defamation, and has actually filed something, but it's not quite a complaint. So we'll talk to my guest about that. And then a little bit later, we have another guest on to speak about non-disclosure agreements. We've heard so much about them in the news lately when it comes to all of these sexual harassment claims. And we want to talk about the specifics, what they are, what they mean, and can they be overturned. She's also going to talk to us a little bit more about a story similar to what we've been watching, and that is opioids and who can be held criminally responsible for this epidemic that's been going on here in the United States. And finally, a little bit of fun today. We're going to be talking about Halloween. Halloween is tomorrow, and there's a lot of legal issues that can arise out of some of the fun that we have on Halloween. So we're going to be talking to one of our lawyers about things like, can you sue a haunted house if you're so scared that you run away and break your nose? You may be surprised at some of the questions and some of the answers. As always, throughout the course of my time here, I welcome you to bring on your questions. Send them to me via Twitter or via the chat rooms, and my guests and I will do our very best to respond to them over the course of the day. To start with, we want to start with the news of the day, which is these indictments that have come down and continue to come down. And for that, we have Gessin. He is a former federal public defender, and now he serves as a white-collar criminal defense attorney out of Orange County, California. Jesse, so happy to have you here with me today.
Thank you for having me.
Oh my gosh, it's my pleasure, because I know you do this stuff. And so having looked at the indictments this morning, and I know that specifically you were able to look at the indictment against Manafort and Gates, what are some of your first impressions? And then I have some specific questions for you.
Right off the bat, wow, this is a very, very interesting indictment. It's very well written, very well crafted. You could tell that they spent a considerable amount of time on the structure and the language of the indictment. It has a very strong narrative up front, and then it does the counts in the back, which is fairly standard, but it reads like a story. And it's also very plain in the sense of the language that they use. So it doesn't use a ton of legalese up front, which is nice. So I think they clearly meant it to read for a general audience, which is great.
That's an interesting point when you say that. A general audience, meaning in large part the media. I mean, you're a lawyer, I'm a lawyer, you focus on these things, but this is the type of indictment that can be read by a journalist, a layperson at home, and they can understand the language, right?
Absolutely. Absolutely. And these are fairly complex crimes involving international corporations, multiple entities. There's tax implications, although they didn't charge a specific tax count. They could always charge that later. Money laundering is the big one.
Right.
And we can get right into that. That is a huge count.
Now tell us why that's the big one, and then we'll talk about the impact of that count. But why is money laundering the big one? And when you say the big one, is it against Manafort and Gates? Or we're showing Manafort on the screen there, but that is the same count against both of them, correct?
It is. It's actually a conspiracy count. It's an interesting count because it's essentially alleging a number of crimes within one count. So the way that that count is structured is that they use the two substantive crimes in Section 1956, which is the money laundering statute, and they roll them into a conspiracy. And a conspiracy is just an agreement to do something unlawful, and in this case, it would be money laundering. The nice thing about conspiracy for federal prosecutors, and by the way, conspiracy has once been described by a federal judge as the prosecutor's darling, because it's so much easier to prosecute that count versus the substantive charges of whatever crime you're charging. So in this case, it's conspiracy to launder money. And what's nice about that charge is that they can, like I said, roll 2 or 3 or 4 different crimes into that one count, because they're really charging not the crimes, but the agreement to commit the crimes. So, and the penalty is oftentimes the same as if the person had committed the underlying charge. So in this case, money laundering carries up to 20 years in prison. And the rest of the charges either carry 5, for example, on the first count is a conspiracy against the United States count, which only carries 5 years in prison, versus the other counts, which are 5 and 10 years respectively for all the other counts. The only one that carries that 20-year count, as far as I can see, is the money laundering count. So it is by far the biggest count.
And when we talk about it being the biggest count, I mean, it's the biggest count because the defendants will face the biggest number of years, but it also is the count that, there's been a lot of sort of talk about the possibility of someone flipping, and either Gates or Manafort, and giving the government information on people in the government, maybe even the president, in response to try to make some sort of a deal. And that's the count that maybe might make it worthwhile to enter into some sort of a deal, isn't it?
Absolutely. If the government's going to lean on Manafort and Gates to cooperate against the president, the count that they would do it with is money laundering, i.e. they would either give a substantial break on what they recommend as a final sentence under that count, or they could even dismiss the count altogether and have them plead to one of the lower counts.
Let's back up a little bit and talk a little bit about grand juries, because I want to make sure that it's very clear to those people watching at home that a grand jury is very different than the trials that we cover day to day here on LawNewz. First of all, the burden of proof is different, right, Jesse?
Yes. The burden of proof is much lower than in a normal criminal trial. The rules of evidence are out the window, meaning that there's no there's no problem with hearsay or some of the other more difficult evidentiary rules that keep a lot of evidence out. They're secret, so there's nobody knows what's going on except for the grand jurors and the United States attorney that's prosecuting the case. And perhaps the most amazing thing about the grand jury is the amount of power they have to get documents. They have subpoena power, so they can issue subpoenas to anybody, including targets of their investigation, which is a very powerful thing. And defense counsel is not allowed in the grand jury proceedings. So what happens in most districts is the counsel actually sits outside of the grand jury proceedings, and when the the person who's being examined in front of the grand jury, or the witness who's being examined in front of the grand jury, has a question, they have to stop and run out of the grand jury and ask their counsel and then run back in. So it can be a laborious process and just infuriating if you're a defense counsel, because you have no idea what's going on. You have no idea of the context of the question. So you really hope to spend a lot of time up front getting to know what the story is with your client, so you can advise them when to plead the Fifth and when not to plead the Fifth. Of course, and when I say plead the Fifth, I mean take the Fifth Amendment and refuse to answer a question because of self-incrimination. But then the government has a final arrow in their quiver, which is they can just grant immunity on that one question, and anything that person says cannot be used against them. But whatever comes from that question, whatever investigation and evidence they turn up based on the answers to that question, can then be used.
Yes. And it's a process an indictment, a grand jury indictment, certainly doesn't mean that it necessarily follows that everyone who has been indicted will be found guilty, because at a trial, all of these people would actually have defense attorneys, the rules of evidence would apply, the standard is different. But in many ways, these indictments, as we've mentioned, may be used sort of to negotiate deals and perhaps get other information against other people, perhaps, that Mueller and his team could be interested interested in. If that's the case and those types of negotiations are going to be happening, how does that normally work? Say Mueller wants more information from Manafort and is willing to negotiate that 20-year sentence down in order to get some information from him. Does he approach Manafort's attorney? Is it a sit down? How does that normally work?
It might already happen. There's such things as pre-indictment deals where before the indictment's even issued, the defense counsel and the prosecutor will get together and craft a deal, and the final step will just be the indictment. I say final step. The final step in the pre-indictment process will be the indictment. What could happen is so from here on in, what's going to happen is Manafort's and Gates are going to show up. They're going to be arraigned on the indictment, which is an official entry of not guilty. In most jurisdictions, you can't even plead guilty at this point. They could theoretically plead guilty if there was a pre-indictment deal and it was all set up beforehand, but most likely not. Most likely what will happen if there's no deal, then they will show up, enter a plea of not guilty, and the discovery process will proceed, in which case the government will turn over all the evidence that they intend to use in their case in chief against Manafort and Gates. At which point, the defense counsel will look at the evidence and start deciding whether or not it's in his client, in this case Manafort and Gates, best interest to cut a deal with the government. This could take a very long time.
Yeah, I think a lot of people were expecting some major thing to happen today. These indictments themselves are sort of major. Now, right before you and I came on air, another indictment was publicized, and I know you haven't had the chance to read the whole thing, Jesse, but I want to talk to you a little bit about it, because it does seem, and our own Dan Abrams, I think, just tweeted that this is the indictment that seems to have more of an impact on the president, if any, than the others. You know, we've talked about Manafort and Gates, then how if Mueller wanted them to give him more information, perhaps he could use that money-laundering count to do so. But this indictment against George Papadopolis is a little bit different, because this is an indictment for which, first of all, he is going to be pleading guilty. Papadopoulos was a foreign policy advisor for the presidential campaign of Donald Trump, and he is pleading guilty to having made material false statements and material omissions during an interview with the FBI that took place in January of 2017. And Jesse, I'm going to just tell you about the material false statements and material omissions that he admits to having made, and I want to get your thoughts on it. He had claimed that his interactions with an overseas professor who had substantial connections to the Russian government officials occurred before he became a foreign policy advisor to the campaign. And that apparently was one of the misstatements that he made. There are others, but this particular indictment that Papadopoulos has pled guilty to, this could have a lot more impact on the president than the Manafort and Gates indictments, don't you think?
Well, the reason that it's more tangentially related to the president is because it was made in the course of and probably for the purpose of the election, right? Or the campaign. It'll really come back to what George Papadopoulos knows and what Manafort knows and what Gates know, because there are misstatements, but they're not. Oh, I told I didn't know the president. You know what I'm saying? They're not directly related to the president.
It's not right. It's not. The president was aware that I was lying to you. The president told me not to say that. Yes. So thus far, there's been nothing that came out today that has made any link there whatsoever.
No, it's not directly linked. So, but it is another person that could provide information. The reason that it's really important to have these indictments against these individuals is so that they can cooperate and provide possible testimony. There might be emails out there, but from what I've read, the president doesn't use email. So it's probably gonna hang on somebody's word as to whether or not the president was involved in any sort of impropriety. Now, whether it's election impropriety, which may be a possibility, or it's something more nefarious like collusion with Russia, will probably hang on somebody's testimony. So what they're doing is they're tightening the noose on the individuals close to the president to try to get information. The fact that they indicted somebody for just false statements, which is kind of a lower level crime, tells me that they don't have a ton on that person. They clearly hit Manafort with everything they had. I thought at one point they might try to go with a lighter indictment and maybe hang the charge over Manafort's head, but they unleashed.
Right.
If they had if they had more evidence on other individuals, then they probably already would have indicted. And that false statement, it's a serious charge. It's a felony, but I believe it's a 5 or even a 10-year statutory max. The statute code is 1001. It's a pretty well-known statute, but they kind of throw it in. They rarely charge just false statements because it is such a considered a loose crime, given that people talk to the FBI all the time.
Right.
They lie to the FBI all the time. Just bringing somebody up on that charge tells me that they're stretching a little bit.
Yeah, and what would be the reason for that stretching? Is it to bring other people out of the woodwork, make people nervous and maybe willing to make some deals? Why would they want to stretch that way?
Absolutely. They probably believe that Papadopoulos has information that they need, so they're trying to lean on him. Exactly same with Manafort.
You know, it's interesting, I said this to you before we went on air, but someone on Twitter or somewhere said something to the effect that if you're Manafort and you're facing 20 years or the wrath of both President Trump and perhaps Putin, you may be smart to just do your time rather than making any sort of deals. If you see a deal, does that usually take a little bit of time to negotiate and go through discovery before it happens? I mean, that's not something that you would expect to see this week or even this month, is it?
No. If Manafort had cut a deal already, then I think we probably would have known about it. There might have been another filing under seal along with the indictment. There doesn't appear to be any other filings. I do believe that they've charged him and they have not made a deal yet, and it could be a while before we see a deal. But I can't imagine that he wouldn't broker some sort of deal. A trial in this case could carry, like I said, up to a 20-year stat max. In the federal system, we used what's called the United States Sentencing Guidelines to give our clients an idea of what they're facing. About 50% of the sentences end up somewhere within the guideline range. So it gives people a better understanding of what they might be facing. The guidelines have to be calculated by the court. They have to be calculated by United States Sentencing, probation. And those guidelines, in Manafort's case, I pinned them at 235 to 293 months.
Yeah.
So he's only 5 months shy of the statutory maximum on his recommended sentence. I'd be afraid of Putin. I'd be afraid of Trump, but I'd be afraid of the Bureau of Prisons at 20 years. Much more.
He's in a tough situation. But Manafort and Gates, they're in the same situation, and it's not a. We keep talking about Manafort because he's the face. While you and I have been talking, we've been showing the pictures of some of the players, and he's the face of this. I think more he and maybe Flynn, who some thought an indictment would come down against Flynn today as well. But Gates is just as likely to flip if he has any information. And we say flip as if the president is within the prosecutor's sights. That may not be the case. There are some other people in the administration. Some have talked about Jared Kushner. Some have talked about Don Jr. There are some other people in the administration who maybe have some things to worry about. But at this point, it's a whole lot of speculation, right? Right, Jesse?
It is a whole lot of speculation. All we know is that Manafort and Gates have been involved in serious felonies concerning money transfers, money laundering, illegal illegal lobbying, but it was all done. It appears to be prior to his service as campaign chairman, and it's definitely not Trump related.
Right.
It appears to be Manafort on his own at this point.
Right.
It's difficult to say though, because Roger Stone and Manafort and Gates were all lobbying partners at one point. Roger Stone is at one point was at one point very close to the president. He of course went on this Twitter rant, probably thinking that the indictment was either probably Manafort and Gates.
Right.
And they were at one point very close. I don't know where they're at today. But he could be a domino that falls. There could be a number of people that end up on the chopping block. Kushner and Eric Jr. Donald Jr. are interesting because their improprieties are probably not Manafort and Gates related, because they don't appear to have been in league with each other in private business or consulting or lobbying. So if any information is going to come out about them, it's going to be most likely it's going to be something that Manafort knew and has held back up until now, and is part of some sort of substantial cooperation. But they have non-Trump related issues.
For sure. It seems as though the majority of what is in the indictment, all of what's the indictment is non-Trump related issues. If there's a Trump related issue for Manafort and Gates, it's not something that's reflected in the 31 pages of that indictment.
That's true.
Let me ask you, Jesse, about pardoning. Now, and I know that this is that's something that gets into constitutional law, and it's something that's been widely debated. But some of the people in our chat room are talking about, well, Trump might just pardon everyone anyway. Now, we do know that Trump did pardon Sheriff Joe Arpaio out of Arizona, and so that has a lot of people concerned that he may use his pardon power relatively loosely. Do you have any opinion on that? Do you think that that's something that we might see, especially here where, as you just said, it's not something that implicates Trump? It seems like politically it would be a bad idea. What about legally?
Well, legally, the pardon power is extraordinarily powerful. He could pardon them. He could simply commute any sentence, which is what happened with Scooter Libby. Mm-hmm. Right. People, there's been talk about whether or not this is a Scooter Libby situation where the president might just watch it play out and then give a commutation. Mm-hmm. But the Sheriff Arpaio pardon was really shocking and surprising, right? For a number of reasons. It wasn't a serious charge. I believe it was a misdemeanor. Still pardoned him. He did it before the sheriff was sentenced. That is a fairly loose use of the pardon power. And here you have Manafort and Gates, who are facing way more serious charges, right. And are probably definitely a lot closer with the president than Sheriff Joe Arpaio was. So I wouldn't be surprised to see a pardon.
Yeah,
no, not at all.
I think that I agree with you. I think that given the fact that our president has certainly showed his hand and his willingness to pardon someone, it's certainly something that we should at least be considering as we have this conversation. I've got to tell you, I listened to the most interesting podcast over the weekend. Ty Cobb, who is President Trump's attorney, it seems to be the one handling this part of his legal issues or legal concerns. Gave an interview to the New York Times, and it was on a podcast. And he seemed, and I want to talk to you a little bit about lawyering, because he seemed so confident that this was a non-issue for President Trump, and certainly had the journalists questioning him or speaking to him very confident that he felt very sure of himself. But first of all, isn't that part of a lawyer's job, whether for good, bad, or indifferent? We are supposed to seem very confident in our case and in our client and completely unruffled.
Absolutely. I listened to the same interview,
Yeah.
and he comes across as very genuine, very plain spoken, and his game plan is very simple: cooperate, cooperate, cooperate,
Mm-hmm.
disclose, disclose, disclose. The problem with the one problem with that is he may not have all of the information, and that's one thing you do when you're with your client when you first get into the case. You say to your client, okay, tell me where the bodies are buried. Tell me what's going on. Tell me this. Sometimes it depends on the case. In this case, that's clearly what he did. It would be unfathomable to craft an entire legal strategy around disclosure and not have asked them to disclose everything. Some cases you may not want to know where all the bodies are buried. It just depends on the case. So he must have sat down with Trump and the other individuals at the White House that may have information and said, look, tell me what's the worst of it, and then decided, okay, that's the worst of it. Let's just cooperate with everybody, and that's what he appears to be doing. The unfortunate thing for Ty Cobb and that strategy is that he could be lied to by his client or the other people around his client, and that happens quite frequently. And you'll be in the middle of some sort of hearing or even a trial, or you'll be sitting down with the government and doing some sort of a proffer, meaning that a proffer is where your client cooperates and sits down with the government, and all of a sudden they ask a question, and then your client says what they have to say, and then they pull out a document, and you're like, oh my God, where did that come from? Right. And it's your client's email directly contradicting what they just said. So I think that the strategy will work if they've been truthful with Mr. Cobb.
Right.
If they haven't been truthful, then it could be a very dangerous strategy.
Yeah, I mean, I agree with you. Ty Cobb seemed completely confident, and I'm sure, just as you said, you know, he was doing a trip around the world, one of those National Geographic trips around the world, when he was called to participate on behalf of the president. And so I'm sure that he asked all the questions, what am I getting into? And he seems quite confident that the idea of, he knows Mueller, they've worked together in the past, and his thought is to just provide everything, give all of the answers. But given that approach, if that is going to be Ty Cobb's approach, then that would sort of stand in the way of the idea that the president would be pardoning people, doesn't it, Jesse?
That is true. That is true. It's definitely, they definitely conflict. Those two, an open disclosure strategy and then pardoning people who might have information pertinent to the investigation. That definitely contradicts each other. The reality is that Ty Cobb can't control Donald Trump. Right. He just can't. Right. And client control is essential to crafting a successful defense strategy. It's absolutely necessary. And you have to be able to convince the client to do what needs to be done in order for the strategy to work. The reality is that in any criminal case, the client only gets to make four choices: whether to go to trial, whether to plead guilty, whether to appeal, or whether to testify. Those are the four choices. Everything else is tactical, meaning that the decisions are made by the counsel. In this case, I seriously doubt that those are the only four choices that Donald Trump is going to get involved in. Right.
He definitely is one of those seems to be one of those clients that would be difficult to keep under control, let's say.
Oh, absolutely. I couldn't imagine dealing with a client that had that much control issues. The nice thing about Ty Cobb's situation is that he can always withdraw. Right. He can always withdraw. It's a little more difficult if he was an appointed counsel or a public defender, but he can always withdraw and move forward. And there may come a time when he has to withdraw if something comes to light that he didn't know about and it requires him to violate ethics or to suborn perjury. That would require mandatory withdrawal.
All right, Jesse, I think that you've gone through all my questions. I'm sure that as we hear more about this, we're going to have more questions, and I'd love to have you back on to continue to explain some of these things to us. Thank you so much for being with us here this morning. We really appreciate your time and your insight and your knowledge.
Thank you for having me.
Have a good day.